McIlvain. I'm the Deputy Executive Director for Programs and Services at the Suffolk Independent Living Organization. There are 42 independent living centers in New York State, one in Nassau, one in Suffolk, and throughout New York State, and actually throughout the country. And we are in line and coordinating services with the New York State Education Department and also Access VR and the Office of the Aging. So that's our claim to fame. And most of the services that are listed here on the first slide are the programs and services that are by county. So we really do cover services in Nassau and Suffolk County. And I'm not going to go through each one of those, but you can feel free to always shoot me an email, and then we can go through each one of those one at a time. I've had parents contacting me for follow-up, perhaps for a peer support group for their son or daughter. So the questions are very individualized, but as you become familiar with silos services, and 90% of the services are free. And I think that's important to note. And it also, a lot of the services cover from birth right up until we go to heaven. So that's, I just wanted to provide a quick overview. And the one that we'll focus on here this evening is my role in terms of assisting families with the review and development of the documentation to support the transmittal form for eligibility with the Office of People with Developmental Disabilities. And often also the same documentation is utilized to support the application for supplemental security income on or after the 18th birthday, or to prepare in advance the documentation if the person, son or daughter, is receiving Social Security benefit attached to a mom or dad and coming up on the 18th birthday, where then there is a review to see if there's a continuation for adult child. And what's important then is to develop the documentation in advance, and we'll go through that step by step as we move forward. The first slide that Regina is bringing up is the transmittal form for eligibility determination. And this is really then the beginning of how to complete a form following the steps that are listed on page 2, which is generally the son or daughter's last name, first name, middle initial in section 1, the involved parent or guardian in section 2, again, last name, first name, middle initial, referring agency. Now, historically, that has often been the school district may be included there, or it could be Brian McIlvain as silo if I was assisting families. Now, more often, it's the care coordination organizations, and we'll go through that, how you will identify one of the 3 care coordination organizations who will then be able to take your documentation and upload it directly into the OPWDD system. Whereas in years past, the packet was mailed to 415A Osser Avenue, and then you had a 10 or 12-week response time to get feedback. Now the care coordination organizations can upload that information directly into their system for you. Now, also then in section 4, most often families would just check off box 14. You check off box 14, that encompasses pretty much everything else within those boxes. Completed by, print legibly, the date, and who completed it by. So that's the transmittal form for eligibility determination, and that begins the process then of what is the required documentation then that goes with the eligibility transmittal form. So on the second slide, and again, these are all attached PDF files, and if you'd like, you can also send me an email, and I'll send you a hard copy in the mail, because I know sometimes we all have difficulty printing documents at home. Now, the transmittal form requires documentation in the manner in which OPWDD expects to receive it. So the onus falls upon the family. And the transmittal form, where years ago it was being submitted when the child was 17, 18, 19, there are families who are submitting transmittal forms for provisional eligibility determination as early as age 3, 4, 5. But the beginning is you need a full psychological, not an abbreviated, not an adaptive. It has to be a full psychological, which is either the WISC, generally under the age of 16, or the WACE over the age of 16, which includes an adaptive. The adaptive is the Vineland 3 or the ABAS. And again, the composite scores we'll go through must minimally be 69 and below to support the transmittal form. So you have a full psych and an adaptive. You also need a medical or specialty comprehensive report. This is often provided for somebody who has a cerebral palsy, a seizure disorder, traumatic brain injury. For autism, and we'll go through that also, it's required that you have an autism specialty report, which generally will include, and we'll go through that also, is the ADOS and the CARS or the ADRI. Those are the two preferred methodologies that support then the psychological and the adaptive with the transmittal form. Now, the documentation, as I review regularly, may have the diagnosis that is sound and meaningful for the purpose of education, but OPWDD would like to see the clear documentation and showing what was the methodology that the psychologist utilized for making that diagnosis. And we'll go through what is an autism specialty report. Social history with a narrative. School districts develop social histories, but also when you work with the care coordination organizations, Tri-County, ACA, Care Design, they will also assist the families with developing a social history that includes a narrative section. You also then have a medical and a physical exam. Now, the social history is also only valid for 1 year. Same with the physical and the medical that you will receive from your son or daughter's doctor. There is no specific form. It's like a physical as if you're going to play sports. Again, it's only valid for 1 year, and it's not on the date stamped received, meaning that if you submit the documentation and during that process, it's already 7, 8, 9, 10 months old, and then by the time they make eligibility determination, it becomes expired, well, that's normal, and you need to submit a new one. If the student or the son or daughter also has a psychiatric disorder, you also want to include the documentation that supports that information so that OPWDD can be made aware of that also. Important then also when we get back looking at the psychologicals, how the diagnosis is listed is important that the developmental disability be listed as first. The IEP and other professional assessments that the document of the developmental disability originated prior to age 22. That's critically important, that the diagnosis of the developmental disability, whether it's autism, PDD, NOS, traumatic brain injury, cerebral palsy, seizure disorder, Asperger's, intellectual disability with Down syndrome, those diagnoses need to be clear and they need to be identified and they need to be established prior to the age of 22. If the person is then 25, 30, 35, 40, okay, you get updated testing, but you still need to have in that updated testing documentation identifying, dated documentation of the onset of the developmental disability prior to age 22. It is important to note that school districts, adult agencies, clinics, and practitioners are in the practice of destroying records after 7 years. So it's the parent's responsibility as their child is going through education, obtain those records and maintain those records, because later on, if you need them, they may have been destroyed and that becomes a problem. Without it, there is no eligibility determination. Now, question that I receive often is that the families may have submitted with the school district a transmittal packet a while back, 3, 4, 5, 6, 7, 8 months ago. Well, here's the email address of where the family can send an email to R05 eligibility at opwdd.ny.gov, and they generally will respond back quickly as to where or what are the questions that you may have. Provide them your contact information, and they could then follow up on where it is in terms of the eligibility determination being made for your son or daughter. It's important then when you begin the process to also identify a care coordination organization. There are 3, ACA, Care Design, and Tri-County. You do not need eligibility to contact them, but it is important to make contact with them because they will work with you to help navigate this process. Also, then you would contact the OPWDD website and register for a front door training. That's a requirement. And nice is that you can do the front door training from home. Now, this is an important guide front door access to services that I forward to the families. And it's nice to read in advance so that as you listen to the front door training, some of the pieces begin to fall into place as to what are those available services that you may then apply for after you receive eligibility, working with your care coordination organization. That's only the beginning. And so for families who are working with their sons or daughters and they're in elementary school, middle school, that's wonderful. They can then go on to college, go into employment. They can navigate everything and anything that they would like to in life. But at the same time, they're working with the care coordination organization as a team effort. And that's critically important. So it's not to say that, okay, why would I want to apply for OPWDD services? It's to say, okay, here's what my son or daughter will need moving forward. And then how do I then identify and apply for those services? And this is a great guide to read. It's well written. I encourage all families. Now, this is a DDP2, and all agencies who provide services fill out a DDP2. It's a disability profile. And what's nice is that it often, I think it's in box 6, it lists what are those most often or frequently identified intellectual and developmental disabilities. This also then will play into what's called the Coordinated Assessment System, CAS. Again, it's an assessment with an agency as to what are the needs of your son or daughter, and here is where it really validates why you would want to apply for and get approved for those services. So this is something that would be filled out with an adult agency. And there, on the disability description, it lists the most frequently identified intellectual disability, autism, cerebral palsy, epilepsy, seizure disorder. Interesting to note on the intellectual disability, the school districts utilize the DSM diagnoses. And generally, that would be for intellectual disability 69 and below. OPWDD uses Office of Mental Hygiene Law. It's a little bit different in how it looks at the overall picture. But it's important to note also, I recently reviewed a psychological on my desk this week, whereas the boy or the girl had a full scale in the 50s and 60s, but the adaptives came up way too high for both the teacher and the parent. That did not warrant then the diagnosis of intellectual disability. So it's important to, as you begin to navigate the system, have a review of your records with a psychologist or a professional who is familiar with the nuances of what to look at in the review of records that are being developed for the educational purposes to see how they then support the transmittal form with OPWDD. Testing forms, this is just a quickly to go over. I keep in my office a copy of the Vineland 3, the ABAS, so that families get referenced as to how do they view the input for their son or daughter when providing input. So you would want to have that discussion with the psychologist as to how you should be reviewing and providing that input.
Brian, just
Yes.
Going back to the DDP2, a parent made a good comment. I was taught that it should be completed as if it's the worst day, when you fill it out. I think you say if you're gone for 2 weeks, what is your expression? You fill out the forms.
I think what we're looking at here is input to the DDP2 must be accurate and honest.
Yes.
And I've been filling those out for somebody who was, say, in a supported employment program, because the DDP2 for somebody who's receiving job coaching services in supported employment would want to mirror the input being provided by the care coordinator or the agency who's providing ResHab or other services. I think what we're looking at here is how the parent may have received information of providing input to an adaptive. So it's apples and oranges.
Okay, and then somebody, if they have a question.
Yeah, so I think the parent would want to perhaps shoot me an email or give me a call and let's review that on an individual basis. But I think, the DDP2 is really accurately what is the disability profile of the boy or girl, because that's going to be followed up with a coordinated assessment system, a CAS. So one is, and that's a very thorough assessment that is now being utilized moving forward, and it really will then help support and validate why individuals may be receiving funds embedded into their self-directed budget. So and those decisions are all determined with the care coordination organization, the self-directed budget, the broker, submitting that through to the local OPWDD, DDRO 5. That's way and above and beyond. So I think what the parent was touching upon was the input for the violent or the ABAS.
Okay, so a couple of things. One, the parents asking about question and answer. So we are being active with the chat box. So use the chat box if you have a question, or use the Q&A. I am monitoring that. One parent just asked, what if there's a discrepancy, obviously, between the DD2 and the CAS? Right?
That's out of we don't get involved with. That's the discussion that they would have with that agency who's providing the input.
Right. But if you submitted documents that have a discrepancy, obviously that's a discussion you should have with, carefully before you submit that to OPWDD, correct?
No, the DDP2 is the transmittal form is submitted with the documentation that then reviewed and determines eligibility. Then the family will apply and work with the care coordination organization. It's then when they start looking at what are those services that may be made available for them to apply for, that those other agencies will then complete a DDP2. So there's no way to skew that. It's going to be accurate.
Right. So some of the comments, okay, so, right. So somebody needs OPWDD for dummies. I understand. So you will be working with professionals, your transition coordinator, people like Brian, to help you understand OPWDD services, and you have to even become familiar. Like Brian was saying, the front door is a good introduction for you. You can also talk to many support groups or parents. And I'm sorry, Brian, you look like you're about to say something, so go ahead.
I think what's important is the focus, the role, the information that I provide to families, to school districts, working with them, is the review and development of the educational documents, and to see, is there sufficient documentation and what may need to be developed to support the transmittal form for eligibility determination. Once the family gets eligibility determination and they're working with a care coordination organization, I'm done. Now the parents are on really an individualized plan that they will be developing with that care coordination organization. And what I can say is that they do a fabulous job, and you would want to work with them and, be supportive. Say the family gets eligibility and the child is 10, 12, 14, but they never then apply for care coordination organization, or they say, my son or daughter is going off to college, or they're going off to work. I'm not interested at this time. So maybe 8 or 10 years go by. They're going to then have to start over again. Right. Even years ago, you had what they said was permanent eligibility. That permanent does not apply after an extended period of time. So the nuances of working with the care coordination organizations and coordinating that with the DDP2 is not a question, or with the coordinated assessment system. I'm sure there are families who have different, but that's not something that we could ever influence. Anyone other than the parent having that discussion with their care coordination organization at that moment in time. So sometimes you'll go to a parent group and you'll hear one or two parents who may bring that up as a point of discussion. They're very familiar with it because it impacts their son or daughter, but that's way ahead of where we are now today.
We're just talking about eligibility.
Yeah, and if we get eligibility, that's a big one. That's the happy dance of then beginning the process. And that's where the focus is here.
Yes.
So to start the discussion and go in reverse, you want to make sure that the Vineland 3, not the 2, which is sometimes I still see to this day somebody who will submit updated testing with the Vineland 2. Well, that's outdated right from the beginning. Also, say the psychological, which is a full site, comes through with the Vineland 3 or the ABAS, and the score came up too high for whatever reasons may be. That can get another testing done, if the Vineland 3 was done, then you get a new ABAS done. If the ABAS was done, then you get the Vineland 3 done. And then perhaps the mom and dad would have a different viewpoint on which is more accurate. So that is a discussion the families could have with the psychologist in terms of getting updated testing done. So that's the ABAS and the Vineland 3. The CARS now is interesting. That's a booklet. And the CARS booklet has 42 items where the parent, caregiver, provides input. And again, it's important that they work with a psychologist who can then speak to the parent and get a sense of their input, because it's the parent's observations of having their son or daughter who live with them, who then the CARS is then scored generally. Nice to have it done first, because then it validates. Then when the psychologist schedules the appointment for the ADOS or the ADRI, that's where they make the clinical diagnosis. That psychologist has purchased the training, they've been trained, they know how to administer. So the blend of the CARS with the ADOS or the ADRI is the preferred methodology. But again, and the CARS as a standalone, generally, that's not sufficient because there is no real clinical diagnosis as determined by OPWDD. The WAIS, that's your IQ, that's generally done after the 16th birthday, and where it really becomes important, and again, you hear a lot of misinformation out there, the full scale, the IQ, really is most important when it comes to intellectual disability. For somebody who has autism, PDD, NOS, Asperger's, traumatic brain injury, cerebral palsy, seizure disorder, the IQ is all over them, highs and lows. So I just want to point that out. But everyone needs an adaptive. And this is the outline of an autism specialty report. So if you identify a clinic or practitioner who will then perhaps utilize your insurance for having that testing done outside the district, you would want to forward to the clinic or practitioner the outline in advance to ensure that they can follow that methodology. And do they have the ADOS and the ADRI as part of their testing protocol? Very important. Often also then, if you're utilizing your insurance, they're going to bundle it with an updated psychological, a new adaptive, and the autism report for the purpose of insurance approval. So you generally, 99.9, you just can't call Empire Blue Cross or whomever hit and say, I need an autism specialty report. No, they're going to do it a whole new evaluation and bundle it all together. If I was to do a review of somebody's review of records developed by the school district, I then respond back in an email with those specific steps, outlining, here's what I've reviewed, here's what my suggestions, and here's the protocol in terms of what is the updated testing you need, who to contact, care coordination organizations, register for the front door training, and put it all together in one clean packet.
There was a question. I'm sorry. Oof. There was a question about the WISC, the Westler. I know it as the WISC-4. It's not on the list of OPWDD tests.
They can always shoot an email to me and I can follow it up and respond back.
Okay.
This is the
Okay.
list of clinics and practitioners that is made available by the local DDRO. So if somebody was looking for getting updated testing, utilizing their insurance, this is the list of agencies, clinics, and practitioners. And again, you would want to, I'm not saying that all of them utilize the correct methodology, so you would want to forward to them the outline of the autism specialty report, if that's what is needed for your son or daughter in advance, to ensure that you're scheduling it correctly.
Okay, so there was a couple of other questions and about the Woodcock-Johnson. Again, I'm not a psychologist, but the Woodcock-Johnson, you can shoot an email to Brian. But from what I understand, Woodcock-Johnson is an intelligence test that they talk about the strengths in the various areas of reading and math and so on. They break it down, so it's a little bit different of a test. I'm not familiar with it as, so you could, it's an achievement test. So you could talk to Brian about that testing. So again, I'm not a psychologist and neither is Brian, but the testing that you provide to OPWDD, okay, so you are a psychologist. So, but again, you'd have to pose that question to Brian so he can forward it to OPWDD for the Woodcock-Johnson, if they accept it, okay?
Yes, and there is a list of testings that are, and I didn't include that in this presentation, but forward to me the question, because you're absolutely correct. It's never going to be my interpretation. I'm going to forward it to somebody, whether it's pertaining to OPWDD, and provide you the source. So if you have an additional question, you want to get the most accurate information. Generally speaking, and I don't have that handout in front of me, it would be a full psychological, not an abbreviated, they then will determine whether that's sufficient.
Okay, so this is the lovely letter.
And this is what we all aspire for, is to receive a letter back from OPWDD determining eligibility. And again, to begin the process, years ago, in order to register for front door training, you needed to have eligibility. Well, they took that out. That doesn't apply. You can register for front door, and I strongly encourage families to do that right from the get-go. Simultaneously, contact the care coordination organization so you're working together with them, who want to work with you and have you as a team member with them. And they're wonderful. They really are wonderful agency to work with. Now, this is the Memorandum of Understanding that we have here at Silo, and here's how this played out. There were families who were having difficulty navigating the system for developing the documentation to support the transmittal form, obtaining testing services, and also the development of the documentation to support the application for supplemental security income on or after the 18th birthday, or if there's a review to be adult child for Social Security disability, to prepare that documentation in advance, generally around the birthday, 17 and a half birthday, to make that available to Social Security in advance so that benefit continues. So we do have available at Silo a flat fee consultant rate for $295, and we'll put it on a payment schedule where I will assist families with the review and development of the documentation to support the entire process. For families who are looking for getting updated testing done, for whatever the reasons may be, they couldn't identify a clinical practitioner, we do also have it available as a consultant testing service, and updated psychological is $750, and adaptive is $250, and the autism specialty report also is $750. So if you can work it with your insurance, that's wonderful. But for families who are unable to, for whatever the reasons may be, we have that available. I also then look at the development of the documentation, because we would want to, if the child's coming up on around their 18th birthday, the similar documentation you're developing for OPWDD, you would want it to support the documentation for the application for supplemental security income, which brings us to the second part of my presentation this evening.
Right. So there was a question back. I will find it. Obviously, just because you became eligible for OPWDD doesn't mean that you're automatically eligible for Social Security income. So
Absolutely correct. You nailed it. The important piece here, and Regina, thank you for that intro. There are three things for SSI, supplemental security income, on or after the 18th birthday. One, no resources in excess of $2,000, savings, checking, CDs, stocks, bonds, 3-year look back. Regina will address that as part of her presentation. So that's the first question. And then also the discussion of child support and how does that play into it. So the first is SSI is no resources in excess of $2,000. That's the beginning. Second, clear medical evidence. So for somebody who has autism, PDD, NOS, Asperger's, traumatic brain injury, cerebral palsy, seizure disorder, Tourette syndrome, intellectual disability, OPWDD eligibility, guardianship, does that entitle them for SSI? The answer is no. Similarly, if there's a review to roll over for adult child, the answer is no. It comes down to the documentation that you're making available to the Social Security Administration and what they will then perhaps obtain as related to functional performance as relates to work. So this is where we look at and review the documentation that you have available and to crosswalk this through with the documentation that may be made available to Social Security. And that's going to be the focus of where we're moving. Now, this is the application for SSI. You may hear in a training, all you need to do is call the 1-800 number and say, hello, my name is Brian McIlvain, and I'd like to assist my son with Brian for his application for his supplemental security income on or after the 18th birthday. Okay. And then sign a release. Well, by doing that, by signing a release, which you will do as part of the process, they're going to obtain documentation from every source. Well, it's nice for you to have all your documentations prepared in advance before you make that call, so you're well prepared and your shoulders kind of relax and you have a nice glass of water available. So the application, you can make an appointment when you make the 1-800 number and make an appointment then to complete the application with a representative from the Social Security Administration who's going to complete it with you accurately. Because if you fill out the application incorrectly, you've already started digging a hole that becomes difficult to correct. So that's the application, and that's how I approach it for the application for SSI.
Brian, I have somebody asked about care coordinators. So a care coordinator, yes, so maybe their job role is to assist with applications for obtaining services and such. But you know, it's almost like a bank clerk. Sometimes you want to make sure that they're familiar with the application and understand the Social Security process. So I would ask the care coordinator that you're working with, you know, how familiar they are with it, and work carefully, because as Brian said, when you submit an application to Social Security, and if it's incorrect, it does take a while to unravel. That's my suggestion. Brian, if you want to add anything to that. Sure.
And here's my take. Here's my honest take on that. And that is the methodology when I began a supported employment program many years ago. It was upon the suggestion by an adult agency representative who said, Mac, you really should learn about supplemental security income and assist the families with the application process prior to then having the families having their son or daughter go out and work out in the community, kind of get the SSI into place, and then go to work for the next 48 years. So I began then getting the training of assisting the families with the review and the development of the documentation. And it's been years and years of training. We're going to go through the steps that I utilize of working with the families. Now, there's a lot of information from a lot of different sources, and the families can navigate it. And I'm not going to say who's better or who does a better job. I don't know. But I'm going to go through my model of how I've been assisting families with the review and development of the documentation. This is my 42nd year.
So, Brian, you assist people with SSI, correct?
Correct.
Okay, so that was, a pointed question.
And the first step I say is don't fill out the application. Let SSI, Social Security Administration, fill it out with you. Then it's done 100% correctly. Next slide.
So there's another question, but I'll wait until you're finished.
When we take a look at the school district psychological and the adaptive and autism reports, we look at what information perhaps is embedded into those records that we will then crosswalk with a functional report adult. Now, as part of the application process, families apply for supplemental security income, they may receive a functional report adult in the mail with a 2-week turnaround time to get it back, or a functional report adult third party, or as a third similar copy of another functional report adult. And this is what I walk the families through. There are 3 similar documents, but they're all should be viewed where the input is coming from the parent caregiver, because that's what gets signed off on the last page. Who provided the information? So we sit down and we have a discussion as to, here's your documentation. Now let's crosswalk it as we go through the specific items as related to your son or daughter's developmental disability, as related to personal hygiene, socialization, development of doing chores, hobbies, interests. So we kind of walk through to see where the families are and becoming familiar with their input in advance, so that if they receive one of these in the mail as part of the process with a 2-week turnaround time, they're comfortable in understanding how their input is going to be reviewed and viewed by the Social Security Administration. So that's one piece of Brian working together with the families. And I have reviewed others that have been completed after the fact that was submitted to the Social Security Administration, because when you go for a hearing, which could be 2 years from now, it is noted in the notice of unfavorable decision as to where did they get the reference to the input to support their notice of unfavorable decision. And I'm choosing my words carefully. Now, the other practices that I work with the family is to assist them with developing a narrative from the parent or mom's brother and sister, or dad's brother and sister, grandparents, older brothers and sisters over the age of 18, to assist the families with them collecting draft narratives or narratives that can then be submitted to the Social Security Administration with a 795 form. So you're preparing your documentation in advance so that when the time of the application is being submitted to the Social Security Administration, you're then forwarding it with the updated psychological, the adaptive narratives that have been developed and attached to a 795. Also, you have a draft functional report adult to provide you information and guidance. So everything gets then, and you may have to respond. We send that a number of times to Social Security. We have to look at for many, many years, the number of individuals who went for their initial appointment at their local office, 25% were approved. 75% would then go see the IMA doctor. And probably about 98% of those would be denied. That's normal. Then they have to file the reconsideration and an appeal. Now, if the documentation is all done correctly, generally the benefits were in place within 3 to 4 months. But if there's information provided from sources that then support employment, then you'll get noted that in a notice of unfavorable decision And I provide families a copy of that so they can really read through it and see it's not my Irish-Polish interpretation, but this is how it's being viewed by the Social Security Administration as to what are they making as a notation in their response back. You'll get a disc 2 weeks before the hearing, which could then be 2 years from now. And perhaps there was a teacher questionnaire that was completed by the teacher in the school district. And on a scale of 1 to 5, it's there. This is how they feel they viewed your son or daughter.
Okay, so let's just back up a little bit. You know, for Social Security, there is that disability, but let's just make sure everyone knows less than $2,000 before you apply for SSI. That's going to be emphasized during my presentation, but they won't even get to the disability questionnaire if you go in there and say, my child has $2,001 in their name, and that's resources. So please think about all the resources that your child may have, that UGMA account that you have for your child. Grandma has the 529 account, the savings bond. So you have to think about all those accounts are resources, and you have to understand that Social Security has a 3-year look-back period before you apply for Social Security income. So if there are any assets substantial, meaning over $2,000, there are various ways that you can spend down or protect or shelter. But I just want everyone to make sure when you apply for SSI, Brian will walk you through it. This is what he does every day. But I just want everyone to understand you have to manage the resources first. And then for assistance for SSI, somebody was asking about, all right, so custodial accounts, we covered that. That is a resource. So somebody, that's wonderful that we reach somebody in Westchester County, but your student goes to a residential school on the island. So what are your questions about OPWDD? Who do you tap? I guess I would first ask the residential school if they're familiar with OPWDD coordination services or your local school district, but you could also talk to Brian. He can assist with OPWDD and or SSI when your child turns 18. So everyone knows that you have to wait until the age of 18, because before that they will consider the family's resources and you will not be able to qualify. Then there's medical improvement. Okay, so somebody was asking about, recertification. So in my mind, Social Security used to do those annual recertifications, those 1 page. Remember that, Brian? They haven't done that in a couple of years, a good 4 or 5 years, maybe even longer. But Social Security doesn't mean that they're not monitoring you. So again, keep it less than $2,000 because it will come up, maybe not that month, maybe not that year, but the following year they will. Go ahead, Brian.
Well, there's a few things. And when the initial application and you go through the process and you receive the initial benefit of, say, 500 and change, you submit your lodging agreement, and then you're up to 800 and change between the federal and the state contribution. Then the boy or the girl may go to work. Well, it's the parent who often is the representative payee, and it can only be one, who's then responsible to inform Social Security about the change in earnings. So then as the boy or the girl go to work, you take the gross, you minus 85, you divide by 2. That's how much the SSI check is going to be reduced accordingly. And if the person is living in a IRA or another residential setting, most often they become the representative payee and the recipient of the benefit. So when we get into the individualized questions, that's a very individualized email that if I don't have the answer, I'm shooting it out to an attorney who works for Cornell University, who generally will respond back within a day or two with the most accurate information available. So, there's no broad stroke to each case, but other than to say it's best to respond in an email. But that's the piece about the SSI. And then if the boy or the girl go to work for a couple of years, they may then be receiving SSD as part of their benefit. And that's where you get into the discussion of staying under SGA, substantial gainful activity. So taking it up into, a lot of different levels of discussion. So that's where you'll hear families saying, well, I need to keep him under a certain threshold, and here's the dollar value. Otherwise, he loses his Social Security benefit. And if that's attached to mom or dad, that could be significant. So that's where you'll hear that piece of information. And as we go up with the change in earnings to $15 an hour, and what are then the numbers of hours that the boy or the girl can work before they go over the SGA a number of times, and that's when the benefit stops. And then how does it get reinstated? So there's a lot of different questions here that are fun, and you want to get the most accurate information.
Okay, so I have a couple of questions.
And then when that review comes through, which it's interesting because it kind of comes through in waves. So usually if one parent receives one, there's usually a number of parents who then also get it at the same time.
Okay, so I have a couple of questions. This I don't understand. So in the medical improvement category, if improvement is expected, your first review generally will be 6 to 18 months. For SSI purposes, generally, we're not clicking off medical improvement category. Is that correct, Brian? I don't fill out these applications, so you tell me.
Here's how medical improvement means. When you applied for SSI, it was based on you were unable to work. Mm-hmm. You provided documentation that was viewed by Social Security as what prevented you from working. Not that you had autism, PDD, NOS, Asperger's, traumatic brain injury. That's one piece of it. But what prevented you from working? So has there been a change in medical improvement as related to the disability as it relates to work? So this is where when somebody would receive that, they may want to make a copy of it, draft their input, and have it reviewed.
Okay. So some of the questions in regard to, let me go back up again. All right, so I think people are confusing. We are just talking first OPWDD. You don't have to wait until age 18. It's, as Brian was talking about, people have applied as early as 3, have applied at 12, 15. We've had even adults over the age of 22, provided that they have documentation before the age of 22, obtain OPWDD related certification and related services. Now, Social Security disability, we are talking about SSI tonight. That is the most restrictive type of program that anyone is on, meaning the resources have to be limited to $2,000, less than $2,000. Social Security disability is something different, whereby Brian was talking about when you work into the roles, you can qualify from SSI to SSDI, but if I'm still tied to SSI, I will be limited to, again, that resource of less than 2,000, because what comes with SSI, Brian?
Medicaid.
Yep, and that's the keys to the kingdom, because OPWDD will certify that you are could be eligible for OPWDD related services, but Medicaid is the provider or the payer of those types of services, and if you want those services, you need to be eligible for Medicaid. Now, separate from SSI, there is a qualifier for Medicaid, and Medicaid has their own threshold, which is less than for 2021. You can have resources if you eligible for Medicaid is less than $15,900, and the income has to be less than $884. So don't panic. There are other ways to shelter income, shelter resources. But again, we are talking about SSI. And then the condition of the disability is there is a definition. And what you could ask Brian separately, you can email him about the narrative information. And the question was, is this a verification of the adaptive scores? I don't know if I would say verification or maybe an elaboration, but go ahead, Brian. I'm not sure if you understand the question. Can you elaborate more on the narrative information? Is this just a verification of adaptive scores? I'm not sure if that's related to OPWDD or the SSI.
For the purposes of OPWDD, the adaptive scores 69 is the cutoff. Social Security, similar for somebody with a developmental disability. The narrative, if we look at a parent provides me the documentation provided by a school district, 126 school districts. They've gone out and had their own testing done by a psychologist, neurologist. Often they use tact. They put positive, then the deficits, and positive. Johnny was like to go off to college. Johnny's participating in this. Johnny is doing that. From the level 1 assessment, Mrs. Smith conveys that Colleen likes to assist in all of these work activities related skills around the home and in the community. So we want to look at what information are you making available that has been developed by the school district, which is often strength-based. We all recognize that. That's the role of the IEP and the coordinated set of activities. Now, let's look at, for the purpose of Social Security, we have to focus then on the development of the documentation or the review of documentation that's going to show the time that Tommy or Susie get up in the morning until they go to bed, as related to, when we crosswalk, social activities, personal hygiene, shopping, going out in the community. Let's look at the characteristics of, first make a list of what are the characteristics about your son or daughter's developmental disability. And now let's build that into a narrative that mom and dad feel comfortable that is going to be conveyed to somebody who may be in Kentucky, in Baltimore, Endicott, New York. You're painting that bigger picture of here's the life that is not captured by the school district necessarily, but is really from the paints the picture as to why it is that my son or daughter, here's this, what they need in order to be supported. And you got to realize this is their application, not their application with mom or dad. It's their application, and framing it from what they can do, take mom and dad out of the picture. That's how I approach it. And that's how the training was provided for me, and to get that into my mindset when conveying that with families and assisting them with, because what happens is the following: we get into filing an appeal, which is after you've been denied, after seeing the IMA doctor. That's generally where most families fall off and say, well, my son or daughter or is in that gray area. Well, when you file the appeal, you identify who the Social Security Administration can contact for additional information, having them provide the input for a 795 statement of claimant. Well, let's prepare those documents in advance. Makes sense. And so it really is including those pieces of information that was scored by the psychologist of the input from the violin. This really provides a bigger and more clearer picture about Tommy and Susie, who live in Babylon, Massapequa, Lynbrook, Greenport, in their family environment. Okay, I think it's very individual.
Yep, you did. So before we go on to room and lodger agreements, there was a question about if a child before the age of 18 has a parent that is retired, on disability, or had passed away. So if you could talk about that.
Following the exact same model, we do the review because there will be a review to see if there will be a continuation as an adult child. And it comes down to exactly what we're discussing here. The same review and development of the documentation for somebody who's going to apply for SSI is similar to the same review and development of the documentation to see if they will then continue as adult child. Otherwise, the benefit stops.
The issue is your child will receive a benefit from a parent that is either retired, on disability, or who had passed away. That would be on the parent's Social Security rolls before the age of 18. And what Brian is talking about, at age 18, you will, or when upon graduation, a certain time period when you will have to determine if that child can become a DAC, a disabled adult child, and continue that same amount of money in regard to going forward. So let's just say the child was receiving $1,200 before the age of 18. You'll have to qualify at age 18, and there will be a continuation of that benefit. Correct. Based upon the parents' roles.
If the DAC was less than the amount for the SSI, then it would be a blend of the two, which would that max out at the living alone rate for SSI. Okay, so a good question about when people work and the formula. There is the red book that you mentioned, and in that red book, there is a formula that Social Security applies. Brian says it so fast because he says it every day, minus $85 divided by 2, and then, then it's offsetted by the SSI benefit. So you take the monthly gross, you minus 85, divide by 2, and that's how much the check is reduced accordingly. Now, there are other pieces that come into that, and that is the simplified version, and that is if you're paid weekly, it's actually the monthly gross the weekly gross multiplied by 4.3. And also then you're getting into the discussion of impairment-related work expenses. So if the individual is taking SCAT transportation, then you would also submit that, and that comes off the gross. So again, those emails, you can send it through and we'll send you back. But as Regina said, the Social Security Red Book is a great document. It's attached as a PDF. If you like a hard copy, send me an email. We'll drop it in the mail. And whether it's from the year 2000 to 2021, they're all the same. It's just the dollar value that changes. Okay, so let's talk about room and lodger agreements. That's completed after the 18th birthday, and generally I suggest $450 a month, and you would then have it signed and notarized with an effective date. Like if we were filling one out now, on line 11 it would say January 1st, because we're already into December. The effective date on line 11 would be January 1st, 2022, and you would then have it signed and notarized and hold on to that, because the initial benefit of, say, $500 and change, that'll be deposited into the joint account You as the representative payee will withdraw that and then contact the Social Security Administration and submit the lodging agreement, and then they'll bring he or she up to the maximum benefit of 8 and change. There's a state contribution, and New York State is one of those states that provide that state contribution, but the federal amount is the living alone, and that's the maximum benefit. Living alone is a financial term. It's not a physical arrangement. So it's also really where you're conveying that you're not sharing anything. You would charge the same for somebody else who comes knocking on your door. And if Talia doesn't pay his lodging, you're throwing his butt out the door. It's all just to convey that you're not giving your son or daughter something which then has a value attached to it. So you just follow the protocol of submitting a lodging agreement after the initial benefit is deposited into the account, withdrawn, and we move forward. And it's a one-shot deal.
Okay, so there was another question about the child receives Medicaid before the age of 18, and will they have to reapply at age 18? A child usually, I don't want to make a assumption, but generally, if your child is probably on the Medicaid waiver program, so before the age of 18, you're through the front door, you're receiving OPWDD related services before the age of 18. That is the waiver program whereby they waive the parents' resources. Again, at the age of 18, this is all about transition planning. There is a trigger that you will have to prepare for those type of governmental benefits to apply for your child. Social Security income will automatically bring Medicaid. Some people do go straight on Medicaid, but I would say a majority apply for SSI to obtain Medicaid. Is that correct, Brian?
Yes. By working with a care coordination organization, their program services are funded by Medicaid. So they're going to do a really great job of assisting you that if you have eligibility, submitting the application for the Medicaid through the local DSS office to get the correct coding to support those services that they may be applying for with OPWDD. If you're receiving SSI, which automatically comes with Medicaid, again, with the care coordination organization, they're going to submit the application through the local office so that the coding is correct to support their services. So you really want to work with a care coordination organization when it comes to the nuances of having a seamless transition for Medicaid funded services with OPWDD. Where it becomes, as Regina, you can take it up a notch all the time. There are families who apply for Medicaid through the New York State marketplace. And so it's separate from initially having eligibility, separate from receiving SSI. So now you get to another land of resource levels and filling out those documents correctly with a care coordination organization.
Okay. So thank you, Brian. I think that's the last slide. I'm going to jump into guardianship, but I just want to do a recap of, so people understand the process. Again, OPWDD is, they're going to determine eligibility for your child, loved one, or yourself. And those type of services generally are, if I can make a broad statement, are generally a better related services than someone that's on straight community Medicaid. So I would advise people to obtain OPWDD related services, especially if your child has a diagnosis before the age of 22. A lot of people think that OPWDD related services or SSI will limit my child. I want them to work. I want them to participate in the community. Well, you do need these services because they will give the supports and services to ensure that your child will participate in the community. I want your child to participate in the community. They'll be working. If they're working, they're paying into Social Security. If they pay into Social Security, I get to retire. One day we all like to retire, and it's just the idea of paying it forward, and your child is active in working or in a program. And it's important, because a child on the couch is not beneficial for the child, it's not beneficial for you. So that's just I'm on my soapbox here. Again, please reach out to the right individuals when you're thinking about transition planning for Social Security and obviously OPWDD. Because as Brian said, it's very technical and it's not easy to do. And OPWDD really scrutinizes the application. So does Social Security for SSI.
I'll make just 2 points, Regina, then you'll have it for the rest of the evening. And the piece with OPWDD is there are 126 school districts. And annually, the 126 school districts will submit approximately 450 transmittal forms for eligibility determination. So they're really focusing in on the students who may be in a life skills program. The students who are mainstream, from my observations, the students who are mainstreamed often are not identified, and families submitting with the school districts the transmittal form. And that population of students who are mainstream are not identified until later on. And what's important to note is that by getting into the OPWDD system, you can then plan for your son or daughter to go on to college, go out into employment, whatever it may be. It works hand in hand. It does not limit in any way, shape, or form, from my experience, but supports every family's efforts. And the most common question asked daily at Silo is housing. There were 50,000 individuals in Nassau and Suffolk County, as per a panel discussion at Toro Law School this summer in August. There were 50,000 individuals with intellectual and developmental disabilities in Nassau and Suffolk County at this time, of whom 65% live with their parents, caregivers, of whom 25% are over the age of 60. So the blending of OPWDD and getting the SSI and letting the boy or girl go to work and go to college, those are all part of the overall package of what we all aspire for, and that is to have our sons or daughters supported out in the community. And I'm glad Regina and I are here this evening getting that message out. But the discussion really should be in the middle school latest. High school, now, it's your son or daughter's going off to college, great. But get all these other pieces into place also. And I'll end it with that. Thank you.
Thank you, Brian, for that. All right, so I'm going to start talking about guardianship. And guardianship is a petition to the court whereby someone is petitioning the court for relief, saying that the individual at the age of 18, because in New York, it's presumed that I will be able to make decisions for myself, ability to weigh those risks and benefits. And it is presumed at that age, at age 18, I am an adult and I can do so. Well, some individuals cannot make those determinations, cannot determine what is a risk and what is a benefit, and have the inability to make those medical decisions. I approach guardianship very carefully with my families. If I were going to represent a family petitioning the court, I want to be certain that the application will be a success, just like what Brian was talking about, all these tests and and the functionality. Guardianship, similarly, will look at the person's functionality and will look at the scores. So it is a mixture. And a lot of times I may have a parent, a well-meaning parent, saying, listen, I need you to make, I need to hire you to petition the court. My son or daughter needs a guardianship because they can't make decisions, or they make stupid decisions. I just want people to realize I'm eligible and I'm far beyond the age of 18 to make stupid decisions. So the ability to make a decision is very subjective. So what you should look at when you're thinking about guardianship, and you should be careful about this, is review of your child's functionality. At age 18, they tend to, or will more than likely not make the right decision, or definitely not make the decision that you would like them to make. But that's different from needing a guardianship. In New York State, there are two types of guardianship: a 17A, which is a plenary guardianship, meaning if I became a guardian over someone under a 17A, it's for life. I don't have to check in with the court right now on an annual basis. I can make decisions for them, healthcare decisions, living arrangements, and so on. You are deeming this person incapacitated. Versus there's the Article 81 guardianship, which can be tailor-made, and that is a proceeding in the Supreme Court. The 17A is in surrogate court. I will say the Article 81 guardianship is a very, a complex type of process. There's definitely a hearing. There's court evaluators, court examiners. There's annual check-ins with the court. You have to file a financial report. You have to file, a status report. And it can be very cumbersome. And for families that are working within OPWDD, front door, having the Article 81 guardianship on top of it could be very time consuming, but the Article 81 guardianship should only be used in very specific circumstances, primarily for a population that has significant intellectual disability, or the developmental disability whereby I cannot understand risks or benefits. Most families go with the 17A. Now, I will mention on our website, we do have a video workshop. It is I think approximately 2 hours long. We do have forms there, and parents could file for that 17A guardianship themselves. But again, I want you to carefully consider that before you file it. Make sure that the scores indicate that the person doesn't understand the risks and benefits. I know you're the expert for your children, but you should have that conversation also with the psychologist to understand if your child can appreciate making those choices in life later on. Some cannot, so the 17A guardianship would be appropriate. So what the surrogate court does look at is similar to what Brian was talking about, OPWDD or SSI. The diagnosis doesn't mean much. It used to be a lot more driven by the diagnosis, but the surrogate court is now looking at functionality and whether or not that person has the impaired ability to understand and appreciate the consequences of their own decisions. And always, for a guardian, they will consider the best. The guardian always has to consider the best interests of the individual. A lot of times when we represent families, we will recommend that the parents, both parents be co-guardians. If there's an adult sibling, we also ask them if you want to consider the adult sibling to be a co-guardian. Not all co-guardians have to be at the doctor's office to make that decision. So I like the idea of co-guardianship because you get more longevity with the guardianship for the 17A. So what happens when you file for a 17A? Well, depending upon the circumstances, the court may appoint a guardian ad litem if the IQ is 70 or above, or if there is something in the file that they want to tease out further. What is a guardian ad litem? A guardian ad litem is an attorney that is in the community. They're appointed by the court, and I will mention this. That attorney may not understand your child's developmental disability. So just because you say that the child has autism or, an IQ of 64, that may not translate for that attorney who's serving as a guardian ad litem. Again, you have to spell it out. You have to mention, no, my child cannot shop. If my child went with $20 or to the store and he bought a pack of gum, he would not or she would not understand how to make change. People could take advantage of my child, easily manipulated in regard to making medical decisions. I know a lot of students or a lot of young people that are afraid to talk to the doctors or have an inability to talk to the doctor, or communication language disorder where they're not understanding what the doctor is explaining to them, so they cannot make those decisions. So you'll have to kind of spoon feed the guardian ad litem and elaborate how the disability is impacting your child. I will just mention the court always does a background check on any guardian that is petitioning. So if there's a CPS filing or if there's a criminal background, I don't want people to panic about it. Sometimes at the age of 18, all of us may have a history, a criminal background where you got in trouble with the law, and it's now 20 years later, you're raising your child and you want to be a good guardian. That will not prevent you from being a guardian. It's just that the court will look into the background and make sure that the guardian that is so appointed will consider the best interests of the individual. There may be a hearing also. I've attended many hearings where the issue may be that one of the parents is not around, we can't obtain consent, so the court will go on the record, and it's all for making sure that the record is clear that we've exhausted all possibilities of trying to locate the other parent. The parent has not supported this child in any way, no child support, no birthday cards, no holiday cards, doesn't even make a phone call. So the court would like to do that on the record because it shows that obviously we've exhausted trying to obtain consent, because parents have a statutory right to participate in this process along with adult siblings, and that also includes half brothers and sisters. So, all right. So there was a couple of questions about guardianship. So how long does it take? Well, I would say if you're applying for Suffolk County and Nassau County, they're being very efficient. Nassau County had a huge backlog, and they are recouping that. Suffolk County is phenomenal right now. We submit petitions and they will put it on for calendar, usually 30 days plus. So there is a calendar date. The calendar date is where anyone could object, including your child. So it's very important that service of process is submitted to the child. making sure that the child has received due process. Obviously, the child in question may not be able to read, but the important part of the whole process is service of process. So after the hearing, it usually takes a couple of weeks before the decree is signed by the judge. Depending upon the circumstances, the holiday and other things, the COVID, the time frame for those decrees were taking from 2 weeks all the way out to 2 months. So just want you to be apprised of that. So there was some questions about, whether or not a child can vote when you have the 17A. Well, that question hasn't yet been decided by case law. So I will just tell you that there is on the books that if I'm deemed incapacitated, in the state of New York, I cannot vote. But the federal law has a different threshold. It talks about the ability to understand and read a certain level. I think it was like a 5th grade level or something like that. But my position is that no one asks whether or not you have capacity when you go to register for voting. And then you show up for the ballot box. I was just at a local voting booth last night. They didn't even check my ID. I submitted my name. I signed my name, and then I went into the ballot box. They didn't ask if I had capacity or not. So this slide, and again, the slides are available. The PowerPoint is just talking about the case trends. I will say that the surrogate courts are really scrutinizing guardianships, and rightly so, because you are taking away somebody's ability to make choices. And that includes the wrong choices, but the ability to take away choices. So they are careful in their review, making sure that this person qualifies. And I will say, the IQ doesn't mean a hill of beans. So I had a case where a young man, he had a developmental disability. He was on the autism spectrum. He was diagnosed with that, and his IQ was about 85, 88. And he had the inability to make decisions for himself. And there was a lot of support in not only in the scores, but also in the narratives of the individuals that were supporting him or working with him. Likewise, that young man, he was interesting. He knew he had a limitation, and he did not want to make those decisions. And he wanted a guardian. He wanted his parents to be a guardian. He wanted his older sister to be a guardian. Obviously, it would have been a different take if he was refusing a guardianship, saying, no, I want to make decisions for myself. I don't want my parents there. So I just don't want you to think that it's a bright line test for guardianship. It is all very fact specific. And again, if you are thinking about a guardianship, have that conversation with the expert. And that expert is usually a psychologist that understands those scores and the functionality and how that disability is impacting your child. So let me just check. So what is the difference between a healthcare proxy and a power of attorney versus guardianship? I love that question. Thank you. So advanced directives. I love doing advanced directives. I just did it for a young man whose parent first came to me and said, I need a guardianship for my son. And I said, okay, let's look at the evaluations. I looked at the evaluations. I said, let me meet your son. So I met her son via Zoom, first time, second time. And yes, he was diagnosed on the autism spectrum, but he understood what I was saying. He understood the risks and benefits, and he wanted to make those choices. And in my opinion, he had the ability to sign off on a healthcare proxy and a power of attorney. He appointed his parents under the healthcare proxy. So what is a healthcare proxy? A healthcare proxy is talking about, I need someone to make medical decisions for me when I am unable to make those decisions for myself. Now, under the healthcare proxy, the doctor wants to speak to somebody, and if I'm injured, I'm in a coma, or I am so stressed out that I cannot make medical decisions for myself, my healthcare agent will step in and talk to the doctor for me. It's a fairly simple form. The requisite capacity to appoint a healthcare agent, you don't have to understand all the medical nuances to appoint an agent under the healthcare proxy, but you have to understand that this person would be making those medical decisions and the risks associated with that. Likewise, with the power of attorney, that capacity needed under a power of attorney is a little bit higher than a healthcare proxy. It's more of a contractual capacity. And I carefully go through with someone to make sure that they understand, I have a power of attorney. I have a healthcare proxy. I want my family members or loved ones to step in case I cannot make decisions for myself. Because quite honestly, I don't want them to go to court. I'm an attorney. I don't want to go to court. Even when I'm getting paid there, I don't even want to go to court because, it's just a process. It's time. It's an expense. And your clients are very nervous there. So the power of attorney is a wonderful tool whereby someone will step in your shoes and do the banking for you, contact healthcare providers, because it does have component, we're talking to the insurance companies, could also talk to governmental benefit agencies to apply for benefits. So the power of attorney is literally a very powerful document, and it even allows, if you so wish to, allow that person to transfer assets out of my name. That's so important, especially for benefits planning. So I love doing advanced directives. And if need be, obviously, where someone doesn't have the requisite capacity, then a guardianship is necessary. Okay, so these are miscellaneous issues that come up. So divorce. So a lot of parents, their divorce, are still great co-guardians. I will just mention the surrogate court doesn't want to make it divorce number 2, where one divorced parent is better than the other divorced parent. They will try to push you through mediation, some sort of settlement, and they really do believe in access to family members. So it is important. Obviously, if somebody is very inappropriate to be a guardian, that's another situation. A standby guardian, so you could appoint yourself or the other parent or adult sibling as the guardian. Then you have standby guardians in place. So on the petition, you could put in priority order. So the standby guardian doesn't act until the guardian is no longer or has an inability to act. They actually have to apply to the court saying, I'm here, I'm ready to act because the guardian is unavailable. So there is that process to go through, and they will be fingerprinted at that point, especially if they're non-family members and so on. Jurisdiction in regard to guardianship. So if I have a guardianship here in New York, it should be valid in many other states, but unfortunately there's about 6 states, Texas included, that doesn't have reciprocity with the guardianship. But I rarely have encountered anyone running into any situations in other states. I will just mention, if you're a guardian here in Suffolk County, obviously you're a guardian in Manhattan, you're a guardian up in, I don't know, Nassau County, or I'm trying to think of another county upstate, sorry. Duration, what I mentioned before, it's for the life of the person. So if you are applying for a 17A guardianship, it is for life until that person may raise their hand up and say, I want to terminate this guardianship. And I will say that these cases are coming up readily than before. And Disability Rights of New York will represent that person in those situations, especially if they feel that the guardianship so granted was inappropriate. I've met individuals with disabilities that live in an apartment, have a job, are on committees, and they tell me a story that they first started out living in a group home under a guardianship. Obviously, they're independent, can manage their way through life. So the guardianship at that point would be inappropriate. So corporate guardianships, there are sometimes a corporate guardian that would be appointed, especially if there's no other loved ones available. Please note, just like what Brian was talking about, within 1 year, the social history, there are 2 doctors. There's either you go with 2 MDs or 1 MD and 1 licensed psychologist. Those reports have to be dated, and the medical expert have had to see your child within 1 year of when you filed for a guardianship. So let me just check. All right, so I answered that. Can you amend 17A to remove someone and add a new adult? If so, is it hard? So my thought on amending a guardianship, you can always call the guardianship department, and you can ask them for the requisite forms. Also, it's available under the Office of the Court Administration. It's New York Office of Court Administration, and you can check under surrogate court, under guardianship, but just call your local guardianship department, whatever county you're in, Nassau or Suffolk or Westchester. And those individuals are there to assist you, and they will give you the forms. Obviously, we do amendments for guardianships all the time. And I can't tell you, sometimes each court is a little bit different. There's supposed to be a uniform court act where all courts are the same and they ask for the same procedures and the same forms. Sometimes there are nuances, so that's why I suggest you go to the individual court. Okay, so the benefit I talked about for a co-guardian is that there's longevity. If I've appointed, I'm the parent, obviously I'm older than the child. And if I appoint a co-guardian that's an adult sibling that is near to the ward or the person who needs the guardianship, if they're a co-guardian, if I die, that co-guardian is still the guardian and can continue on. If they are a standby, they have to apply to the court. And depending upon if the statute changed, they may have to actually reapply in its entirety, meaning they have to submit the expert doctor affirmations and affidavits accordingly. So I do like the co-guardianship more so than the standby for ease of for families. If hopefully that answered your question. So I always go for guardianship of the person. I will just mention, please, if your child is before the age of 18, let's think about how to spend out that money. If you have some savings bonds, or if you have a bank account that's only in your child's name, because what will happen is if your child doesn't have the requisite authority, after the age of 18, you may need a court order to obtain, that asset. If you need a court order, you have to file for a guardianship of the property. And it's a process with the surrogate court. We're very familiar with it. But personally, if my child was before the age of 18, I would either change the bank account, make myself as joint so I have access with my child, or do something with the savings bonds, spend it down for that lovely laptop that your child needs. Okay, so let me just see. All right, so I'm going to next talk about, this is special needs trust. So special needs trust. The whole first part of the presentation was talking about accessing eligibility and governmental benefits. Now that you've worked so hard to get there, you want to make sure that the benefits stay in place. And we talked about resources, the limitation on resources, and there's different thresholds. SSI, the most restrictive is less than 2,000, all the way to if I was a person, a working person with a disability on Medicaid, I could have resources up to $21,000 and a salary of $61,000. So there are different thresholds, but no matter what, you want to prepare for or build an estate plan whereby monies don't go directly to your child or loved one. The reason being is that will impact his or her benefits. So a supplemental needs trust is a trust established by statute whereby you could do two types of trust. One, a third-party trust, meaning it's third-party money. It's mom's money, it's dad's money, it's Aunt Kathy's money, and you could set it up whereby the beneficiary is the child, and there are trustees in place, and it could be the parents, it could be other loved ones, and they are going to manage the money. They're going to hold the money as a fiduciary. They have an obligation to your child. They are not supposed to give any money directly to your child, because if they do, that's access to funds. And if you do that, Social Security and or Medicaid will say, well, this is a sham. And obviously whatever is in that account is available to your child, and it will impact benefits. The other type of special needs trust is when it's in your child's name. So for example, sometimes there is an accident and your child is going to be the beneficiary of an award, and it's going to come in his or her name. They're going to receive $85,000. Well, in those circumstances, what you need to do is obviously, and while your child's on governmental benefits, is still protect that, but put it into a trust. And it's the kind of trust I really don't like to do, but if it's necessary, it's called a first party or a clawback trust or a payback trust, meaning upon your child's passing, that $85,000 would go to the Department of Social Services. That is the type of trust that we counsel here, everyone at Brandow Law, tell individuals and families, that's the money that you need to spend down first. Don't reach into your own pocket. Use that money first, because obviously upon your child's passing, it will go to the Department of Social Services. So we guide people how to spend the money. Again, it cannot be accessible to your child. They can't serve as trustees. And there's a lot of individuals that have the requisite authority or decision-making ability and may receive an award, and they will be the grantor of their own trust, appoint their family members as trustees, and they understand they don't have access to these monies, and the trustee will pay for things. I need a new laptop. They will pay for the laptop. I need to go on a trip around the world. They will pay for the trip around the world. And it's always above what the government benefits provide. So Social Security provides food and shelter. So you have to be very careful with these trusts if you're paying for their rent, because there is a term from Social Security. What is it, Brian? Like kind? Remember you were talking about, room and board, independent person. So if you say you are buying toilet paper for someone and you help them out in the food shopping or something like that, that will diminish their benefits. So you have to be careful understanding what benefits your child is on. And your advocacy for your child doesn't end when they graduate from school. And I highly recommend, there are some great benefits counselors at Silo, and they will teach you about the different benefits that your child can access. And I highly recommend that the child participate so they have an understanding and appreciation of what thresholds, what resources that they have to maintain, and other benefits that they can access. We didn't talk about SNAP. We didn't talk about HEAP. And as Brian was talking about, there's housing benefits too. In self-direction, there are some wonderful benefits to assist for housing and utilities. So I'm sorry, I'm just going to take a break and look. Okay, when would you use a pool trust? That's an excellent question. Pool trust. Sometimes I would use a pool trust. Definitely after the age of 65, I would be using a pool trust for my income if I had too much of an income and I wanted to qualify for Medicaid. But there are other times that I would use a pool trust. So, and it all depends upon the circumstances. Sometimes there is an income that's going to come in over the years, and utilizing a pooled trust may be more beneficial than the first party special needs trust. But both are similar, because if something happens to my child under a pooled trust, it will go to the pooled trust company, which is a not-for-profit that assists people with disabilities. So it's not going to go to your child's loved ones or, children if they have children. It will revert back to the pooled trust company, just like under the first party trust, it will revert back to the Department of Social Services. So depending upon, it's very fact specific. I will just tell you there's also an analysis that you have to do under the first party S&T. You may be under court jurisdiction depending upon the circumstances and what court you're in. So it may be better to not use a first party trust and utilize a pool trust, because a pool trust company will monitor and make it compliant, make sure that you're compliant with Medicaid. Under first party trust, I will just note trustees have to account each and every year to the Department of Social Services. And I don't want to, make anyone fearful. It's the accounting, depending upon the circumstances or how complex it is. It's about a 6 or 7 page form. And once you do it the first time, parents can do it each and every year. I have clients that come to me first to do the accounting. We show them how it's done. We give them a sample form, and then they submit it themselves going forward. So it all depends upon the circumstances. So I couldn't give an answer in regard to pool trust in every scenario, but definitely after the age of 65, because the first party trusts aren't available then. Okay, so there was a question about, waiting on doing a special needs trust for your child. And so there are different, either way, you need to build a plan. And you could build a plan where within your will, you can have a testamentary supplemental needs trust that is established when you die. Because quite honestly, as a parent, you are your child's governmental benefits. You are OPWDD, you are SSI and Medicaid. Those benefits are there because one day you will not be there. And whatever assets you have, you want to ensure that they're held for your child. So it is important to have a plan in place, and that's what you're doing. I mean, you're here tonight talking about transition planning, obviously making sure that your child is going to avail themselves to the best benefits that they can to have a very enriched life. And if you're not there, you want to continue that. So that's the importance of special needs planning. And obviously, why plan for the future? You already heard me talk about you're going to preserve the public benefits, and you're going to make sure that your child has a certain quality of life, which is so important to you. Now, what we do is we make sure that not only there's a will and a special needs trust, but we also review your beneficiary forms. So your beneficiary forms are so important. A lot of times, some of your assets are larger than the actual, assets through a will. A lot of people save their IRAs for a lifetime, and they have very significant amount of money in there, and they need to make sure that it's going to go to their disabled adult child to a special needs trust that's properly drafted. And I will tell you that IRS came out with a new statute whereby under the Secure Act, your disabled adult child, the child with a disability, still maintain certain tax advantages on their own life expectancy. IRA rules changed recently. What happens is now, if I die and I leave it to my child, who is the age of 35, that IRA that rolls over to him or her has to pay out within 10 years. And that could be a significant tax consequence depending upon their income tax bracket. What's nice that the IRS has done is for a child with a disability, it will still maintain that life expectancy. So under that life expectancy, your IRA continues to grow. That same child at 35, the life expectancy, let's just say, is 55 years. That IRA will, continue to invest and grow, and income will be generated and go through the trust for the life of your child. So that's an important aspect of it. ABLE accounts are really nice little accounts. When they first came out, people were really jumping up and down for them. I will just note, ABLE accounts are not good estate planning tools, because ABLE accounts, you can deposit up to $15,000 each year into an ABLE account for the child with the disability, provided that they had a disability before the age of 26. It's a little bit different than the age of 22 for OPWDD purposes. But, and cumulatively, you can save up to $100,000 without impacting their benefits. But if something happens to your child, again, it reverts back to the Department of Social Services. So ABLE accounts are not good estate planning tools, but I like ABLE accounts for those circumstances when, number one, your child, like I had a case where a child is receiving, $12,000. So obviously that's a shoo-in. Let's not do a trust. Let's just put the money into an ABLE account, and the child is still maintaining their governmental benefits, which is wonderful. Also, the ABLE account has some provisions in there whereby it could pay for certain things and is accessible to the child without impacting their governmental benefits. So think about ABLE accounts. In New York, there is an ABLE account, My New York ABLE. There's frequently asked questions. You can go through that. I think tonight we've really inundated you with a lot of information, so I'm not going to go into the details of it all. Okay, so ABLE, a good idea for savings. A lot of people use it for the individual who is working to keep certain Medicaid thresholds or certain thresholds for SSI. So an ABLE account is sometimes a very good, effective tool. I have worked with one of Brian's colleagues, Tina Benstead, and we love ABLE accounts, how we can try to manage them, and how individuals on governmental benefits, where it could assist them in certain aspects with their rent without impacting their Social Security, so which is nice. So please look at those frequently asked questions under the ABLE account. This is talking about, we already reviewed first party, third party, and pooled trust. And each one, it's all very fact specific. I will mention that we do have an intake process. So if you did call the office for questions, we have an intake process, and we do have courtesy, brief phone calls. If you had a quick question about certain issues, we take an intake and we schedule a call. So if you had a quick call similar to Brian, just a phone call away, that's how we do it. We schedule these calls and we try to answer your questions in a timely manner, and so on. Obviously, if it's a little bit more involved, it's something else. So I think I'm all talked out, and I think it is 2 hours, Brian. What do you think?
Well, before I introduce Diego, who's been sitting here patiently with me, that's my dachshund, there were 2 points that I just wanted to bring up, and that is, when the benefit is deposited into the joint account, it is important that the representative payee withdraw the funds each month, because if it goes past the $2,000 mark, the next month you're ineligible for the benefit and they'll want that money back. The other piece also is that annually, the family representative payee will receive correspondence from the Social Security Administration asking, okay, last year your son or daughter received $10,000 in benefits. How is the money utilized? And that's where you then come up with the formula of, say, 450 times 12 for lodging, and then food, clothing, whatever else you want to put there. What they're really looking for is that you are not saving the funds. So you'll say balance, savings, checking, $200, $300, whatever it may be. But that's where it's also important is annually that correspondence, and it's pretty, difficult, or you need to navigate the wording, but it's really the balances that you didn't save the money. And that's just what I wanted to put out there.
Okay, so contact information. Somebody asked way beforehand about contact information. One, you could call Brian, 631-880-7929. I know that number by heart, huh, Brian?
An email is great if you could email, and I think it's on the contact for the registration. Yes. That's the best way. So we can say, okay, Brian, are you available tomorrow at 9 o'clock or 11 o'clock on Tuesday or Thursday? And if you don't hear from me in a day or two, send it again, because, we all get a little lost navigating life.
Yes, yes.
But if you,
likewise, yep. Yeah. Likewise, my contact information is on the flyer, and you can reach out by telephone or through the website. So thank you, everyone. And I hope
99% of the time the question's already been asked. So it's not like it's a new question, but it's good to get the accurate information. Sorry, Regina. Thank you.
No, that's true. And just to let you know, sometimes it's very hard. Sometimes somebody will send me an email and, I need to open up when will I open up an ABLE account? So, or they'll ask me one question, but I probably have 20 questions before I make an answer, right? So it's important to have a dialogue. So have patience with us, because we want, as Brian said, to give an accurate answer. So this is our last transition meeting for the year. It was a pleasure, and I hope everyone has a safe and wonderful holiday, and enjoy your loved ones. Brian, can we see Diego?
Diego, where are you?
Oh, he left. I can't put my dogs on my lap, so Brian gets to show his dog at the end. So.
Hey, happy holidays. Diego, behave yourself.
Yes, he doesn't look like he behaves himself. So thank you, everyone, and be well. Take care, Brian.
Thank you. Good night, Regina.
All right, take care. Bye.